the International Tribunal for the Prosecution of Persons Responsible for Serious Violations of International Humanitarian Law committed in the territory of the former Yugoslavia since 1991, more commonly referred to as the International Criminal Tribunal for the Former Yugoslavia or ICTY, is a body of the United Nations established to prosecute serious crimes committed during the Yugoslav Wars, and to try their perpetrators. The tribunal is an ad hoc court which is located in The Hague, Netherlands. The court was established by Resolution 827 of the United Nations Security Council, which was passed on May 25, 1993. It has jurisdiction over 4 clusters of crimes committed on the territory of the former Yugoslavia since 1991, grave breaches of the Geneva Conventions, violations of the laws or customs of war, genocide, and crimes against humanity. The maximum sentence it can impose is life imprisonment. Various countries have signed agreements with the UN to carry out custodial sentences. The final indictments were issued in December 2004, the last of which were confirmed and unsealed in the spring of 2005. The tribunal aims to complete all trials by the end of 2012 and all appeals by 2015. With the exception of Radovan Karada 3/4 year whose trial is expected to end in 2014 and Ratko Mladic and Goran Hada 3/4 year, who were not arrested until 2011. The United Nations Security Council called upon the tribunal to finish its work by December 31, 2014 to prepare for its closure and transfer of its responsibilities to the International Residual Mechanism for Criminal Tribunals which began functioning for the ICTY branch on July 1, 2013. The tribunal will conduct and complete all outstanding first-instance trials, including those of Karada 3/4 year, Mladic and Hada 3/4 year. It will conduct and complete all appeal proceedings for which the notice of appeal against the judgment or sentence was filed before July 1, 2013. Any appeals for which notice is filed after that date will be handled by the residual mechanism. Hada 3/4 year became the last of 161 indicted fugitives to be arrested after Serbian President Boris Tadic announced his arrest on July 20, 2011. History Yugoslav Wars and Genocide The former state of Yugoslavia was divided into separate republics, leading to a war that caused severe civilian casualties on all sides. When discussing the events of the 1990s, historians and sociologists have used the phrases war crimes and genocide to describe the actions of military leaders, especially those of Croatia and Bosnia. The term genocide is often controversial and is separate in meaning to mass killing because it implies the killing and displacement of an entire ethnic, national, racial, religious or political group during the Yugoslav Wars. The Srebrenica massacre became the most infamous systematic killing of a religious group on European soil since the Holocaust. More than 2,000 Muslim men, women and children were killed by Serbian troops. Coined after World War II by Raphael Lemkin and adopted by the United Nations General Assembly in 1948, the term has developed into one of the most crucial laws of international cooperation. In its brief history in international law, the understanding of genocide has helped lawmakers to create a reasonable method for prosecuting accused perpetrators of OED crimes of crimes as stated by historian William Sherpas, which has led to the creation of tribunals such as the ICTY. Creation United Nations Security Council Resolution 808 of February 22, 1993 decided that an international tribunal shall be established for the prosecution of persons responsible for serious violations of international humanitarian law committed in the territory of the former Yugoslavia since 1991, and calling on the Secretary-General to submit for consideration by the Council a report on all aspects of this matter, including specific proposals and where appropriate options taking into account suggestions put forward in this regard by member states. The court was originally proposed by German Foreign Minister Klaus Kinkel. By May 25, 1993, the international community had tried to pressure the leaders of the former Yugoslavian republics diplomatically, militarily, politically, economically, and with Resolution 827 through juridical means. Resolution 827 of May 25, 1993 approved S/25704 report of the Secretary-General and adopted the Statute of the International Tribunal annexed to it, formally creating the ICTY. It would have jurisdiction over 4 clusters of crime committed on the territory of the former Yugoslavia since 1991, grave breaches of the Geneva Conventions, violations of the laws or customs of war, genocide, and crime against humanity. The maximum sentence it can impose is life imprisonment. Implementation In 1993, the ICTY built its internal infrastructure. 17 states have signed an agreement with the ICTY to carry out custodial sentences. 1993-94, in the first year of its existence, the tribunal laid the foundations for its existence as a judicial organ. The tribunal established the legal framework for its operations by adopting the rules of procedure and evidence, as well as its rules of detention and directive for the assignment of defense counsel. Together these rules established a legal aid system for the tribunal. As the ICTY is part of the United Nations and as it was the first international court for criminal justice, the development of a juridical infrastructure was considered quite a challenge. However, after the first year the first ICTY judges had drafted and adopted all the rules for court proceedings. 1994-95, the ICTY established its offices within the Eigen Insurance Building in The Hague and Detention Facilities in Scheveningen in The Hague. The ICTY hired now many staff members. By July 1994 there were sufficient staff members in the Office of the Prosecutor to begin field investigations, and by November 1994 the first indictment was presented and confirmed. In 1995, the entire staff numbered more than 200 persons and came from all over the world. Moreover, some governments assign their legally trained people to the ICTY. Operation equals. In 1994 the first indictment was issued against the Bosnian Serb concentration camp commander Dragan Nikolić. This was followed on February 13, 1995 by 2 indictments comprising 21 individuals which were issued against a group of 21 Bosnian Serbs charged with committing atrocities against Muslim and Croat civilian prisoners. While the war in the former Yugoslavia was still raging, the ICTY prosecutors showed that an international court was viable. However, no accused was arrested. The court confirmed 8 indictments against 46 individuals and issued arrest warrants. Bosnian Serb indictee Duško Tadija became the subject of the tribunal's first trial. Tadija was arrested by German police in Munich in 1994 for his alleged actions in the Prajeda region in Bosnia-Herzegovina. He made his first appearance before the ICTY trial chamber on April 26, 1995, and pleaded not guilty to all of the charges in the indictment. 1995-96, between June 1995 and June 1996, 10 public indictments had been confirmed against a total of 33 individuals. 6 of the newly indicted persons were transferred in the tribunal's detention unit. In addition to Duško Tadić, by June 1996 the tribunal had Shamir Blawakia, Drena 3/4 Nerdamovia, Zejal Delalia, Stravomasia, Asad Landa 3/4 and Hazim Delia in custody. Erdamovia became the first person to enter a guilty plea before the tribunal's court. Between 1995 and 1996, the ICTY dealt with miscellaneous cases involving several detainees, which never reached the trial stage. Some of the accused had been arrested and others surrendered to the ICTY. Accomplishments In 2004, the ICTY published a list of 5 successes which it claimed it had accomplished, spearheading the shift from impunity to accountability, pointing out that, until very recently, it was the only court judging crimes committed as part of the Yugoslav conflict, since prosecutors in the former Yugoslavia were, as a rule, reluctant to prosecute such crimes. Establishing the facts, highlighting the extensive evidence gathering and lengthy findings of fact that tribunal judgments produced. Bringing to justice thousands of victims and giving them a voice, pointing out the large number of witnesses that had been brought before the tribunal. The accomplishments in international law, describing the fleshing out of several international criminal law concepts which had not been ruled on since the Nuremberg trials. Strengthening the rule of law, referring to the tribunal's role in promoting the use of international standards in war crimes prosecutions by former Yugoslav republics. Organization: the tribunal employs around 900 staff. Its organizational components are chambers, registry and the office of the prosecutor. Prosecutors The prosecutor is responsible for investigating crimes, gathering evidence and prosecutions and is head of the office of the prosecutor. The prosecutor is appointed by the UN Security Council upon nomination by the UN Secretary-General. The current prosecutor is Serge Bram-Mertz. Previous prosecutors have been Ramacu Denesco Salam of Venezuela, Richard Goldstone of South Africa, Louise Arbour of Canada, Erika Stberg of Sweden, and Carla Del Ponte of Switzerland, who until 2003, simultaneously served as the prosecutor of the International Criminal Tribunal for Rwanda where she led the OTP since 1999. David Tolbert, the president of the International Center for Transitional Justice, was also appointed deputy prosecutor of the ICTY. Chambers encompasses the judges and their aides. The tribunal operates 3 trial chambers and 1 appeals chamber. The president of the tribunal is also the presiding judge of the appeals chamber. Judges: there are 20 permanent judges and 3 ad litem judges who serve on the tribunal. UN member and observer states can each submit up to 2 nominees of different nationalities to the UN Secretary-General. The UN Secretary-General submits this list to the UN Security Council which selects from 28 to 42 nominees and submits these nominees to the UN General Assembly. The UN General Assembly then elects 14 judges from that list. Judges serve for 4 years and are eligible for re-election. The UN Secretary-General appoints replacements in case of vacancy for the remainder of the term of office concerned. On October 21, 2015, Judge Kamil Agius of Malta was elected president of the ICTY and Liu Daquan of China was elected vice president. They will assume their new positions on November 17, 2015. His predecessors were Antonio Cassis of Italy, Gabrielle Kirk-MacDonald of the United States, Claude Jordan of France, Meron, Fausto Picara of Italy, Patrick Robinson of Jamaica, and Theodore Meron of the United States. Registry The registry is responsible for handling the administration of the tribunal. Activities include keeping court records, translating court documents, transporting and accommodating those who appear to testify, operating the public information section, and such general duties as payroll administration, personnel management and procurement. It is also responsible for the detention unit for indictees being held during their trial and the legal aid program for indictees who cannot pay for their own defense. It is headed by the registrar, currently John Hocking of Australia. His predecessors were Hans Holthus of the Netherlands, Dora the Copyright Ida Sampaio Garrido Nijgh of the Netherlands, and Theo van Borven of the Netherlands. Detention facilities Those defendants on trial and those who were denied a provisional release are detained at the United Nations Detention Unit on the premises of the penitentiary institution Hooglanderen, location Scheveningen, located some 3 kilometers by road from the courthouse. The indicted are housed in private cells which have a toilet, shower, radio, satellite TV, personal computer and other luxuries. They are allowed to phone family and friends daily and can have conjugal visits. There is also a library, a gym and various rooms used for religious observances. The inmates are allowed to cook for themselves. All of the inmates mix freely and are not segregated on the basis of nationality. As the cells are more akin to a university residence instead of a jail, some have derisively referred to the ICT as the A-OE Hague Hilton Euro. The reason for this luxury relative to other prisons is that the first president of the court wanted to emphasize that the indictees are innocent until proven guilty. Indictees. The very first hearing of the ICTY was referral request in the Tadia case on November 8, 1994. As of August 2014, the tribunal has indicted 161 individuals, and has already completed proceedings with regard to 141 of them. 18 have been acquitted, 74 sentenced, 13 have had their cases transferred to courts in Bosnia and Herzegovina, Croatia and Serbia. Another 36 cases have been terminated either because indictments were withdrawn or because the indictees died before or after transfer to the tribunal. Of the 74 convicted, 51 were transferred to 14 different states where they served their prison sentences, excluding those whose sentences amounted to time spent in detention during trial. 50 have served their term, and 3 died while serving their sentences. Proceedings for another 20 indictees are still ongoing. €4 are in the trial phase and 16 are before the appeals chamber. The indictees ranged from common soldiers to generals and police commanders all the way to prime ministers. Slobodan Milojevic was the first sitting head of state indicted for war crimes. Other high-level indictees included Milan Babić, former president of the Republika Srpska Krajina; Ramush Haradinaj, former Prime Minister of Kosovo; Radovan Karađa III, former President of the Republika Srpska; Ratko Mladić, former commander of the Bosnian Serb Army and Anti-Gotovina, former general of the Croatian Army. Haradinaj's trial began at The Hague on March 5, 2007 and the closing brief was given on January 23, 2008. The final decision of the ICTY was expected in March 2008. On April 3, 2008, ICTY issued a public notice of the Haradinaj verdict, in which he was acquitted of all charges. The judge said much of the evidence had been non-existent against Haradinaj or at best inconclusive. But he complained of witness intimidation, saying some witnesses had not testified because they had been afraid. On July 21, 2010, the cases of YK commanders Ramush Haradinaj, Idris Baloj and Lej Ibrahimović were reopened for trial. However, on November 29, 2012 all 3 were acquitted of all charges for a second time. The cases as of August 2014, there are 4 ongoing trials: Goran Hada ¾ Ratko Mladić, Radovan Karađa ¾ and Vojislav Angstrom AELJ. Each case is in the process of judgment by the courts, with the cases for Karađa ¾ and Angstrom AELJ due in late 2015. The case of Karađa ¾ was brought to the public eye once again in July 2015 with the 20th anniversary of the Srebrenica massacre, which resulted in the deaths of as many as 8,000 men and boys by soldiers under the command of Karađa ¾ Controversy has played a part in the case of Angstrom AELJ, with one judge being disqualified in 2013 for having demonstrated an unacceptable appearance of bias in favor of conviction, which is in violation of Article 20 of the ICTY statute. Article 20 empowers the judges to ensure that a trial is fair and expeditious and that proceedings are conducted to allow for the full respect for the rights of the accused and due regard for the protection of victims and witnesses, infusing due process. Since late 2014, Angstrom's AELJ has been in Serbia awaiting his verdict due to humanitarian reasons concerning his health, which has deteriorated over the course of the trial. 5 further cases are at the appeals stage: and Orlevia, Piria Ia, Popovia AL, Angstrom Novia AL, and Ptolemy cases. An additional 23 individuals have been the subject of contempt proceedings. Croat Serb general and former president of the Republic of Serbian Krajina Goran Hada III was the last fugitive wanted by the tribunal to be arrested on July 20, 2011. Criticism: skeptics argued that an international court could not function while the war in the former Yugoslavia was still going on. This would be a huge undertaking for any court, but for the ICTY it would be an even greater one, as the new tribunal still needed judges, a prosecutor, a registrar, investigative and support staff, an extensive interpretation and translation system, a legal aid structure, premises, equipment, courtrooms, detention facilities, guards and all the related funding. Criticisms of the court include: Moscow has criticized the ICTY as being ineffective, costly and politically motivated. On December 6, 2006, the tribunal at The Hague approved the use of force-feeding of Serbian politician Vojislav Angstrom AELJ. They decided it was not torture, inhuman or degrading treatment if there is a medical necessity to do so, and if the manner in which the detainee is force-fed is not inhuman or degrading. Reducing the indictment charges after the arrest of Ratko Mladic, Croatian officials publicly condemned Chief Prosecutor Serge Brammertz for his announcement that the former Bosnian Serb general will be tried solely for crimes allegedly committed in Bosnia, not in Croatia. Critics have questioned whether the tribunal exacerbates tensions rather than promotes reconciliation, as is claimed by tribunal supporters. Polls show a generally negative reaction to the tribunal among both Serbs and Croats. A majority of Serbs and Croats have expressed doubts regarding the ICTY's integrity and question the tenability of its legal procedures. 68% of indictees have been Serbs, to the extent that a sizable portion of the Bosnian Serb and Croatian Serb political and military leaderships have been indicted. Many have seen this as reflecting bias, while the tribunal's defenders have seen this as indicative of the actual proportion of crimes committed. However, Marko Hall claimed that, aside from Milo Evija, only Moma Ilopiria, who was acquitted, has been indicted from the Serbian military or political top when it comes to wars in Croatia and Bosnia. According to Hall, a former employee at the ICTY, an investigative team worked on indictments of senior members of the joint criminal enterprise, including not only Milo Evija but also Veljko Kavajavic, Blaga Jada 3/4 year, Borisav Jovic, Branko Kostia, Momir Bulatovic and others. However, Hall claims that, due to Carla Del Ponte's intervention, these drafts were rejected, and the indictment limited to Milo Evija alone. There have been allegations of censorship. In July 2011, the appeals chamber of ICTY confirmed the judgment of the trial chamber which found journalist and former tribunal's OTP spokesperson Florence Hartman guilty of contempt of court and fined her a $7,000. She disclosed documents of Former Yugoslavia's Supreme Defense Council meetings and criticized the tribunal for granting confidentiality of some information in them to protect Serbia's vital national interests during Bosnia's lawsuit against the country for genocide in front of the International Court of Justice. Hartman argued that Serbia was freed of the charge of genocide because ICTY redacted certain information in the council meetings. Since these documents have in the meantime been made public by the ICTY itself, a group of organizations and individuals, who supported her, said that the tribunal in this appellate proceedings imposed a form of censorship aimed to protect the international judges from any form of criticism. Klaus-Peter Willsch compared the anti-Gotovina verdict, in which the late Croatian President Franjo Tuđman was posthumously found to have been participating in a joint criminal enterprise, with the 897 cadaver synod trial in Rome, when Pope Stephen VI had the corpse of Pope Formosus exhumed, put on trial and posthumously convicted. Some sentences have been considered too mild sentences, even within the tribunal, complained at small sentences of convicted war criminals in comparison with their crimes. In 2010, Veselin Angstrom-Ljevananin's sentence for his involvement in the Vukovar massacre was cut from 17 to 10 years, which caused outrage in Croatia. Upon hearing that news, Vesna Božanić, who had been in charge of the Vukovar hospital during the fall of the city, said that the ICTY is dead for her, for crimes that he, Angstrom-Ljevananin, had committed in Vukovar, notably at Ovara. He should have been jailed for life. I'm outraged. The Hague-based tribunal has showed again that it is not a just tribunal. Danijel Rahak, the head of Croatian Association of Prisoners in Serbian concentration camps, said, "The shock of families whose beloved ones were killed at Ovara is unimaginable." The court made a crucial mistake by accepting a statement of a JNA officer to whom Angstrom-Ljevananin was a commander. I cannot understand that. Pavel Struga's 8-year sentence for shelling of Dubrovnik, a UNESCO World Heritage Site, also caused outrage in Croatia. Judge Kevin Parker was named in a Croatian journal as a main cause of the system's failure for having dismissed the testimonies of numerous witnesses. Some of the defendants, such as Slobodan Milo Evija, claimed that the court has no legal authority because it was established by the UN Security Council instead of the UN General Assembly and so had not been created on a broad international basis. The tribunal was established on the basis of Chapter 7 of the United Nations Charter, the relevant portion of which reads: the Security Council can take measures to maintain or restore international peace and security. The legal criticism has been succinctly stated in a memorandum issued by Austrian Professor Hans Karl-Paragrafchler, which was submitted to the President of the Security Council in 1999. British Conservative Party MEP Daniel Hannan has called for the court to be abolished, claiming it is anti-democratic and a violation of national sovereignty. The interactive thematic debate on the role of international criminal justice in reconciliation was convened on April 10, 2013 by the President of the General Assembly during the resumed part of the GA's 67th session. The debate was scheduled after the convictions of Ante Gotovina and Mladen Marko for inciting war crimes against Serbs in Croatia were overturned by an ICTY appeals panel in November 2012. The ICTY President Theodore Meron announced that all three Hague war crimes courts turned down the invitation of UNGA President to participate in the debate about their work. The President of the General Assembly described Meron's refusal to participate in this debate as scandalous. He emphasized that he does not shy away from criticizing the ICTY, which has convicted nobody for inciting crimes committed against Serbs in Croatia. Tomislav Nikolic, the President of Serbia, criticized the ICTY, claiming it did not contribute but hindered reconciliation in the former Yugoslavia. He added that although there is no significant ethnic disproportion among the number of casualties in the Yugoslav Wars, the ICTY sentenced Serbs and ethnic Serbs to a combined total of 50 years in prison, while claiming that members of other ethnic groups have been sentenced to a total of 55 years for crimes against Serbs. Vitaly Churkin, the ambassador of Russia to the UN, criticized the work of the ICTY, especially the overturned convictions of Gotovina and Ramush Haradinaj. Response to criticism equals. Supporters of the work of the ICTY responded to critics in various publications. In a response to David Harlan's selective justice, Jelena Subosha, an assistant professor of political science at Georgia State University and author of Hijacked Justice, Dealing with the Past and the Balkans, responded that the critics of the tribunal miss the point, which is not to deliver justice for past wrongs equally for all sides, fostering reconciliation, but to carefully measure each case on its own merits. We should judge the work of the tribunal by its legal expertise, not by the political outcomes we desire. Marko Hawk claims the accusations of the tribunal's selective justice stem from Serbian nationalist propaganda. He wrote, "This is, of course, the claim that hardline Serb nationalists and supporters of Slobodan Milosevic have been making for about the last 2 decades. Instead of carrying out any research into the actual record of the ICTY in order to support his thesis, Harlan simply repeats a string of clichés of the kind that frequently appear in anti-Hague diatribes by Serb nationalists." See also, Command Responsibility, Joint Criminal Enterprise, International Criminal Court, International Criminal Tribunal for Rwanda, Trial of Gotovina et al. Thematic debate on the role of international criminal justice in reconciliation. References. Further reading. External links. International Progress Organization, Monitoring of the ICTY, Del Ponte, Carla. The Role of International Criminal Prosecutions in Reconstructing Divided Communities, public lecture by Carla Del Ponte, prosecutor, International Criminal Tribunal for the Former Yugoslavia, given at the London School of Economics, October 20, 2003. Topical digests of the case law of ICTR and ICTY, Human Rights Watch, 2004, Hague Justice Portal, Academic Gateway to the Hague Organizations Concerning International Peace, Justice and Security. Calendar of court proceedings before the ICTY, Hague Justice Portal, Why Journalists Should Be Worried by the Rwanda Tribunal Precedents by Thierry Cravelier for Reporters Without Borders, Sense News Agency, a special project based in ICTY, complete web-based video archive of the Milosevic trial, war crimes, conditionality and EU integration in the Western Balkans, by Virgin Dmitrijevic, Florence Hartman, Dejan Jovic, Tija Memisevic, edited by Judy Batt, Jelena Obradovia, Chalot Paper No. 116, June 2009, European Union Institute for Security Studies, introductory note by Fausto Pekar on the Statute of the International Criminal Tribunal for the Former Yugoslavia in the Historic Archives of the United Nations Audiovisual Library of International Law, Procedural History of the Statute of the International Criminal Tribunal for the Former Yugoslavia in the Historic Archives of the United Nations Audiovisual Library of International Law, lecture by Fausto Pekar entitled Completing the Mandate, the Legal Challenges Facing the International Criminal Tribunal for the Former Yugoslavia in the lecture series of the United Nations Audiovisual Library of International Law, lecture by Fausto Pekar entitled Contribution of the International Criminal Tribunal for the Former Yugoslavia to the Development of International Humanitarian Law in a lecture series of the United Nations Audiovisual Library of International Law, lecture by Patrick Lipton Robinson, Fairness and Efficiency in the Proceedings of the International Criminal Tribunal for the Former Yugoslavia in the lecture series of the United Nations Audiovisual Library of International Law.